Florida probate will humble you because in this state, even when everyone thinks they did everything right, even when there's a typed out will, 2 witnesses, and quiet signing that took place at a kitchen table, one tiny mistake can blow up your entire estate plan. And today's story, well, let's just say you can't make this stuff up. I'm Attorney Otto, a Florida estate planning attorney. And on this channel, I break down real Florida court cases, the ones that sound unbelievable, but are absolutely real. So you can protect your family from the same mistakes. And this story is a Florida appellate case decided in 2019 called Bitetzakis versus Bitetzakis. In this case, a man tried to sign a will, but he never fully signed his name. And because of that, his entire will was thrown out. Now, let me walk you through exactly what happened and why Florida law is so strict about getting will signing exactly right, not close enough. Our main character, Greg Bitetzakis, and I may be saying that name wrong, but that's how I pronounce it. A Florida man doing something very responsible. He's trying to sign his will. It's September of 2013. He's at home. His wife is home with him. 2 witnesses are there, and everyone believes they're doing this correctly. The witnesses sign the will, and Gregory picks up the pen to sign, and he actually begins signing his name at the end of the document. He writes his first name, Gregory, and then starts on his last name, but stops before finishing it. Not because he changed his mind, not because something went wrong medically. He stops because his wife turns to him and says, "Babe, wait, don't finish that. I think we need a notary." Now, anyone who practices estate planning in Florida knows this. A Florida will does not need to be notarized to be valid. Now, do we have strict rules? Absolutely. But is a notary required? Absolutely not. But Gregory didn't know that. And his wife, well, she meant well. So he put down the pen on that day and they decided that they would finish everything the next day. And this moment right here is where the entire estate plan started to unravel. The next day they drove to a notary, but they didn't bring the will with them. Instead, Gregory signed a completely separate document called a self-proven affidavit by himself, without the original witnesses present. Now that means several critical things happened. 1, he never finished signing the will. 2, the witnesses never saw him complete his signature because he never finished it. 3, the affidavit was signed alone after the fact. 4, the formal execution of the will was broken beyond repair. Now fast forward to 2017, Gregory passes away. His will, the one that was never fully signed, is submitted to probate. The probate court initially allows it, but then the challenge comes. His daughter objects and argues that the will was not properly executed under Florida statute, section 732.502. And guess what? She was right. The appellate court reviewed the facts very carefully and they asked 3 simple questions. Did Gregory sign the will using his full customary signature? No. Number 2, did the witnesses actually see him sign the will? No, he never signed it fully. 3, did the notarized affidavit signed make the mistake go away? Absolutely not. The appellate judges were very clear. A partial signing, when someone normally signs their full name, does not satisfy Florida's signature requirement. A self-proven affidavit cannot validate a will that was improperly executed. And most importantly, intent does not save you. Formalities matter. If you don't follow them exactly, the will is invalid. And I want to point out here that no one was contesting whether or not Gregory actually intended to sign this document. Everyone in the room knew that. The wife knew, the judge knew, the witnesses knew that. No one was contesting that. We just wanted to know, did he do it the right way? And the answer was he didn't. So the appellate court reversed the probate decision. The will was thrown out and Gregory's estate was treated as if he had died without a will at all. His entire estate plan failed over one missing signature. one moment, one misunderstanding, one technical mistake. You can't make this stuff up. So let's talk about the lessons, because this case teaches 3 critical things that every Florida family needs to understand. Lesson number 1, Florida requires your full legal signature, not a half, not initials, not a nickname. If you normally sign your full name on deeds, bank documents, and legal paperwork, then Florida expects the same signature on your will. Anything less puts the document at risk. Lesson number 2, witnesses must be physically present. They must watch you sign, they must sign in front of you, and they must sign in front of each other. Any break in that chain, even a very short one, can collapse the entire will. And Florida courts do not bend on this requirement. Lesson number 3, a notary does not replace witnesses. A Florida will does not require notarization, but it absolutely requires 2 witnesses. Good intentions and bad information destroyed this will. And that happens more often than people realize. Now let's talk about the real human impact, because when a will gets thrown out in Florida, it's not just paperwork. Families fight. Someone feels cheated. Someone blames someone else. Thousands of dollars get spent in court. Siblings often stop speaking, and the person's actual wishes disappear, all because of a technical mistake. And that's why I tell these stories, because when it comes to wills, close enough is legally the same as invalid, like it never happened. So if you're watching this and thinking, wow, this could easily happen to us, you are absolutely right. And here's how you protect your family. Work with a qualified Florida estate planning attorney, not Google templates or ChatGPT or do-it-yourself kits. Make sure all signing happens in one sign-in ceremony with everyone present, signing together, watching each other sign. Now, use your full legal signature, the same one that you use everywhere else. Do not rely on a notary. Use 2 adult witnesses, preferably unrelated. And don't assume. Ask a professional. Florida probate law is strict, and mistakes are expensive. This case is dramatic, but it's not rare. Every single month, families are torn apart by small sign-in mistakes. Half a signature, a witness stepping away, someone saying, it's fine, I'll just notarize it, or I'll get to it later. And when it all blows up, families are left in complete disarray. Don't let this happen to you or your family. If you found this video helpful, please share it and hit subscribe. Turn on your notifications so you don't miss another episode of You Can't Make This Stuff Up. I'm Attorney Otto. Plan wisely, live confidently, and I'll see you next time.